Okay. Okay. Hi everyone. My name's Caitlin,
I'm Laura.
I'm Drew.
and we're Group 1, and we're going to be covering Chapter 10, Recruitment, Tenure, Dismissal, and Due Process. Um, so to start us off, we get to talk about the fun topic of tenure. The tenure contract is designed primarily to provide a measure of security for teachers and to ensure that they are protected from arbitrary and capricious treatment by school authorities. Any teacher who earns tenure or continuing service status also acquires a property right or a legitimate claim to the teaching position. Once a property right is acquired, the teacher may only be dismissed for cause, which we'll explain that in a little bit. Full due process provisions must be applied. So, acquisition of tenure, how do you get it? In a number of states, tenure may only be attained after the teacher has successfully completed three successive years during the probationary period and receives an offer of reemployment for the succeeding year. The probationary period is one in which the non-tenured teacher is seeking tenure. During the probationary period, a teacher may be non-renewed at the end of the contract year without cause or dismissed during the year with cause. In the case of the latter, the teacher must be afforded full due process rights.
Non-renewal, the primary reason due processes does not apply to probationary status centers around a limited property interest. During the probationary period, the teacher typically is offered a one-year contract, which is renewable each year if the school board elects to do so. If the probationary teacher then only has a property right for the duration of the one-year contract. When the contract period ends each year, the teacher loses the inherent property right because both the teacher and the district have met contractual obligations to each other. Due process and cause are necessary only if there is evidence that a property interest continues to exist. A property interest does not exist if no legal contract is in force.
Now we go into teacher evaluation. So as the teachers go through evaluation, the quality of teachers has a profound impact on student learning outcomes. That's what administration looks for. The systems provide teachers with vital information to assist them in improving their teaching in their effectiveness when they're linked with meaningful professional development programs. Teacher evaluation should include teachers and evaluators working as a team to improve teaching and learning. So the evaluation process isn't more or less the teacher being told, "Hey, you need to fix this. This is what you're good at." It's them working with their administrators to see what they can work on together. The system should focus on multiple measures regarding teacher performance. Then, as teachers, we also hear about feedback all the time, and feedback should be an essential piece of assisting teachers to improve their performance.
Next, we come into dismissal for cause. Tenure laws include grounds for dismissal in virtually all states. While there are variations among states, these grounds normally include incompetency, insubordination, immorality, neglect of duty, justifiable decrease in the number of teaching positions. So, for some reason, a department would move from 5 math teachers to 3. Removing the extra 2 math teachers is legal, or financial exigency. So if all of a sudden the school loses a bunch of funding and they cannot pay to have that many teachers on, that's also legal. And a statement indicating other good and just cause, which we will elaborate on. Incompetency is classified, or it's considered one of the more frequent grounds for dismissal. Charges of incompetency are going to be the most common. Most commonly, incompetency refers to inefficiency, a lack of skill, inadequate knowledge on subject matter, inability or unwillingness to teach the curriculum, unfair or failure to work ineffectively with colleagues and parents, failure to maintain discipline, mismanagement of the classroom, and attitudinal deficiencies. So, like, having a bad attitude. So, like, having a bad attitude.
Okay.
So, like, having a bad attitude. 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 So, like, having a b
Okay, then insubordination is generally viewed as the willful failure or inability to obey a reasonable and valid administrative directive. So if you're purposely not turning in your lesson plans or not reporting to your duties, this is where they can get you for insubordination. You're not doing what your contract has said you're going to do, and it's kind of like you're choosing not to follow those. There are some instances in which one serious violation may form the basis or charges of insubordination. Documenting teacher misconduct. So teacher misconduct regarding school issues must be thoroughly investigated and documented. When documentation is complete, the teacher should have an opportunity to respond in writing, and then sufficient time must be provided the teacher to remedy the behavior based on the nature of the misconduct. The teacher should subsequently remedy the undesirable behavior.
Now we get into immorality. Immorality is cited in relevant state statutes as grounds for dismissal involves conduct that violates the ethics of a particular community. Some state laws refer to immorality as unfitness to teach, or a behavior which sets a poor example for students and violates moral integrity. So essentially, it leads back into not being able to teach the curriculum and also being not the figure that a school wants you to be in front of students.
Now we have criminal activity. Obviously, this is a big no-no. Charges of criminal activity committed by public school teachers will normally result in dismissal based on general unfitness, immorality, and unprofessional conduct. Depending on the severity and specifics of the criminal act, revocation of the teaching certificate also may be appropriate, especially in cases where conviction occurs. So obviously, something as simple as a speeding ticket is going to be handled very differently than, say, participating in a bank robbery. So that is where, in most cases, the smaller instances are going to be left up to the district and their policies to handle. But in major cases, complete removal of teaching license and teaching certifications being pulled can be the result. In a number of states, conviction of a felony or crime of moral turpitude will form defensible grounds for the revocation of the teaching certificate. So again, those larger scale criminal events or activities. In other instances, a series of convictions for misdemeanors may also prove sufficient to remove a teacher from an employment position by revocation of the teaching certificate. So again, if there's a large pattern of, speeding tickets or driving under the influence, some of those things that may be considered a little bit smaller, but if there's a repeat behavior of it, it can become a safety concern, and then it can be treated as a larger scale situation.
Financial exigency, the violation of position. So financial occurs when the district faces a bona fide reduction in its budget, which results in abolishing certain employee positions. Positions may also be abolished when the district encounters reductions in student enrollment. So based on students, if they need to get rid of teachers, that might be part of the financial cuts and cutting teachers. Neglect of duty occurs when a teacher fails to execute assigned duties. Neglect may be intentional or unintentional based on ineffective performances. So the courts will support what the district says. That demonstrates the need to reduce their teacher force, commonly called reduction in force or RIF, where there is evidence that a legitimate financial problem exists, and then the due process is then provided.
There's also something called good or just cause. So just cause is designed to provide a district broader latitude in dismissing teachers for causes not specifically identified in state statutes. It is not designed to allow districts to dismiss a teacher for personal, political, arbitrary, or capricious reasons. So they have to either be just, have a just cause for dismissing the teacher. They may not be specifically in the state statutes or within the Department of Education within that state, but they can't be due to personal reasons. So you can't have this personal vendetta with his teacher and be like, "Hey, we're canning you just because we don't like you." That's not how that works. So they have to be just and they have to have a specific reason.
Collective bargaining. Collective bargaining has grown in popularity and appeal in public education. Although it has always provoked controversy, many educators view collective bargaining as a mechanism to achieve a greater role in management and operation of public schools. So, to the public or people who don't necessarily work in education, it can be a bit of a dicey topic, but most people, specifically educators who are filling the administrative role, kind of see it as a way to grow or a stepping stone and better made the building, the district, so on and so forth. Since many of the issues involving collective bargaining center around rights of employees, terms and conditions of employment, the very nature of it sometimes invokes conflict and adversarial relationship between school boards and union representatives, because you're in most cases arguing about benefits, salary, days off, things that the employee probably wants a little more of, and the employer probably doesn't really want to give more of. Most states currently permit some form of bargaining between teachers and school boards. Again, remember, union powers are usually kind of fighting in the corner of the teachers, so that does bring on a larger role for them. These agreements may vary from required bargaining to some form of meet and confer provision. So in some states, there is required to be some amount of, hey, I want this, give and take, so you're not just saying, yep, sounds good, great, and moving on. An example of this is the Janus versus AFSCME case. It represents a landmark decision by the United States Supreme Court regarding labor law involving the power of labor unions, which, like I mentioned, they're usually kind of fighting in the corner of the teachers in a lot of these bargaining situations, and how they collect fees from non-union members. The Janus ruling clarified that mandatory union fees are a form of government coercion that violates workers' rights. Employees cannot be forced to financially support labor unions to hold a government position. The Janus decision restored First Amendment rights to millions of public sector workers.